argument,
Yes.
which unfortunately my equipment was already sent to court when that arrived.
We've also just literally just received it a few minutes ago.
Right.
It's a 40, the usual length of 42 pages.
So it's yes, I can see it's Mr. Manuel's computer that's been activated, but as long as we get that
Yes.
during the course of the day.
I'm sure, my lord, after the first break, I'm sure Mr. Breitenbach will conduct a fiscal copy.
His one junior is in court.
Oh, at least. Yeah.
Good. Yes, thank you, Mr. Mpofu.
Thank you, my lord. My lord, so then I'll start now with my own housekeeping, the applicant's own housekeeping. My lord, you would have seen, as we've just described now, that there are mountains and mountains of paper in this matter. And thank God we started the case today, otherwise there would have been more, because it looks like every day there were documents coming in. It is therefore my duty, my lord, particularly as the applicant, to cut through those mountains and try to situate the case and signpost it. The reason why we have these mountains is because this is quite an important matter. It's an involved matter. Effectively, multiple applicants and multiple respondents, multiple reliefs against different people and so on. So it's quite, it looks intimidating. But in the next few minutes, I'm going to try and really cut it down to size, and then I will follow, that will also be signposting the route that our argument will follow as the applicants. I know that I won't be long because as applicant I get a second bite at the cherry. When I do the reply, after my colleagues have also argued, I will also then resituate the matter depending on what points are being pursued or no longer pursued or not seriously pursued and so on.
So, Mr. Mpofu, just before you start with your argument proper, just to the IT and the registrars on duty,
Yes.
we have a portable router in the courtroom. So the laptops are set up on that now. I think it's the Huawei router that runs on the Telkom network, apparently. I have given to my registrar via the PIN code for my personal router, that in case that one goes off, then you can connect my one, that portable one that's there. Ms. Davids has the PIN code for it. That's not for council's convenience. It's just so that we don't have interruptions in the court.
Housekeeping on that side of
Good.
the bench. Yeah.
Yes, thank you, Mr. Mpofu.
Thank you, my lord. My lord, I must say that before I go back to what I was saying, I know that I speak for all my colleagues when we want to really thank your lordships for having gone through what I call these mountains, but more importantly, for the preparedness to sit a few extra hours if necessary, of course. And because that has enabled this matter, which could have been a 3-day or even a 4-day matter, to be condensed into 2 days. Back to what I was saying, my lords. My departure point is going to be that there are certain essential facts and certain essential cases, authorities, which I will call the Big Five, which really situate what this case is all about. Of course, as counsel, we will refer you to hundreds and hundreds of other cases. But these 5 cases in my respectful submission encompass both the background, the issues, as well as the type of relief that we seek. So I'll outline them just now. Then, on the factual side, despite these mountains and mountains, I will demonstrate both in my main argument and again in reply that there is, in every case there's always that particular item. Here, the particular item that I will keep on coming back to is the meeting of the 22nd of February 2022. And in our private discussions, we refer it as 22-22. It's one of those dates that you cannot forget. Now, flowing from that meeting, it will be an easy and a convenient springboard from which to illustrate very complex issues around why we say there is a festival of illegality that attends to the conduct and actions and decisions of the respondents. And as I say, it's just a convenient tool which we'll use. Obviously, the facts traverse a number of years. So we'll be referring to some of the facts that precede that date and some of the facts that succeeded up to literally yesterday, as your Lordship, the presiding judge just pointed out. Now, if we use that as a template and say the principles that come from the big 5 cases and then the activities on the factual side that are related to that meeting, that will, in combination, once the argument has been properly developed, then take us to where we should start. You know, everyone always says, where do we start with all this? I normally just say, let's start at the beginning. It helps. And where is the beginning? The beginning is literally the beginning, and that is in the notice of motion. And your Lordships will, if again, just to avoid running up and down to the amended notice and all that, your Lordships, just for convenience, the amended notice has not been opposed, and therefore I would simply ask your Lordships to go to literally page 1 of these papers.
Of the
volume 1 of the main index.
yeah, no, I'm there.
Yes. Actually, page 2.
It starts on page 2 because the page 1 is just the introduction, and then
yes,
1.1
is correct.
1.1 is no longer applicable.
That's correct.
Yeah.
So I will simply ask for convenience, your Lordships, to just scratch out the words concerning at 1.6 and put commencing. That was even if you just insert it by pen, that was the amendment that was agreed to by everyone else, just so that we don't have to go to the actual amended notice. That's just a typo, a clerical amendment. Now, the relief that is set out at page 2 and at page 3. That is the Part B relief. So, as it was said very elegantly in the Gordhan, EFF versus Gordhan matter, the court will be expected at various points, which I will signify, to pick onto the Part B relief. And the rationale for that, which was given in the EFF versus Gordhan matter, was because of what I call, at least, a more convenient reformulation of the so-called outer test. Because you'll remember that in Gordhan, EFF versus Gordhan, Hampepe J said that the duty of the interim court, such as you are, is to do two things: pick into the grounds of the main relief, and also determine whether they are likely to succeed. Very important phrase which you'll hear a lot about, likely to succeed. So that's the only relevance of the Part B relief. Every time we'll be cross-referencing that, because your lordships ultimately are going to have to determine that. I say that's a more convenient test because it's, in my estimation, respectfully, much easier to apply than the so-called clearest of cases standard in the raw formulation of outer. But I think conventional wisdom is that the two are not necessarily different. I just prefer the more nuanced approach in the EFF. So then back to page 2.
So just on that point of taking a peek into the Part B relief sought, I noticed on the papers that were filed either yesterday or Sunday evening late, it was your further papers, included in that is the application to the Constitutional Court to reconsider the refusal of the rescission.
Correct.
Now, your Part B, the last part of Part B, the relief there to develop the common law, there you also seek direct access on that specific relief.
On that part, yes.
How does that affect us here?
All right. In short, the submission of the more recent application, which forms part of the so-called respondent's practice note, which is incorporated into our Rule 65E. What it does, my lords, is to, as we say in the Rule 65E, is to restore, or we say that in our practice note actually, is to restore the status quo ante. Let me explain ante the 6th of May. Let me just explain how that works. You will remember that the relief that is sought, contrary to gossip lines, as it were. The relief that is sought there is actually twofold. It's a declarator, and that's the primary relief.
Yeah.
And then it's the rescission, and then it's reconsideration. Now, what that does, particularly well, all of that relief, what it does is to, if you like, bring back the alternative relief that you'll find on page 3. In other words, effectively, the alternative relief that you find at page 3 now relates to the current application, rather than the one that was filed in February, rather in March, on the 11th of March. And therefore, it is still competent for your lordships to grant the relief at prayer 2. That's number one. Number two, that relief, what your lordship, for shorthand, let's call it the current Constitutional Court application, also makes live the matter that Mr. Masuku will deal with more, namely the sub judice Rule 89 issue. And while I'm there, let me just say, for the sake of convenience, that I will very briefly touch on that. So I'll leave that matter to be dealt with by Mr. Masuku. If there's any need for me to address it, I'll do it in reply, but I'm not going to waste the court's time with that issue. Simply to flag it, because it's a crucial aspect of the rule of law in its own right. Mr. Masuku, no doubt, will deal with the interpretation of that rule, its application. What is in dispute, at least in this particular matter, is, for lack of a better words, the application and interpretation of the rule. Nobody disputes that the rule exists, but it is sought to be dodged by the expediency of interpretation. So that's the answer to that question. Those are the implications for yourselves, my lords, of the latest application.
Yeah.
But of course, your lordships are not, particularly in relation to the relief in part in prayer 2. Your lordships are not engaged, contrary to what some of the parties try to do, particularly the DA. Just as before the 6th of May and now, your lordships are not engaged with the merits or demerits of that application, particularly in the context of Rule 45A. They are simply concerned by the fact that it is there and what are the legal implications thereof. Let me illustrate that point quickly so that we don't waste time when we get there. Effectively, the common law relief that we sought pre-6th of May does this. Again, it sounds legalese and all that, but it really is very simple. All it does is to say that the common law should be developed such that a rescission application is treated in the same way as an application for leave to appeal. That's really the simplest way to explain that relief. It simply says, because Section 34 guarantees of the Constitution, guarantees the right to access to the courts, there is no logical reason why, if there's a judgment and then I appeal it, then it's automatically suspended.
That's Section 18.
That's Section 18, yes. It's automatically suspended by operation of law. Why is that so? Nobody says, as long as I just put a notice of application for leave to appeal, it's not for the court to then say, but you only have 2 grounds here and these grounds are flimsy or whatever. No. You simply put an application for leave to appeal and then the judgment is automatically suspended. Why? Because, and this is the fallacy that most people make, that rule is not about really the appeal itself. That rule is about the vindication of the constitutional right to access the courts. Because, so goes the rule, it goes back to the common law. Because it would be foolhardy and Pyrrhic victory for an appellant to win, quote unquote, 2 years down the line, but the judgment has been long implemented. And if it's a car or a piece of food or whatever, it's already been consumed. I'm exaggerating for the fact. That's the underlying rationale, common law rationale for that rule. And therefore, what we will argue in Part B, and again this goes to this issue of picking, what we will argue in Part B is that the same considerations of of Section 34 of the Constitution should apply to a rescission, because it's the same thing. Why must I be protected by the law when I've put an appeal, but I'm not protected if it's a rescission? Because it has the same effect. The relief I'm seeking in both instances is setting aside the judgment. And if it's set aside, then I should be protected. But that's an argument for another day. And
Madam Paul, let me ask you this. The landscape is somewhat changed.
Yeah.
Because now the applicant is requesting a reconsideration or rescission of the rescission, refusal of the rescission.
Yeah.
So that landscape, that argument that you make has somewhat been chameleonically changed.
No. Let me explain Justice Bell. You see, there's this whole thing about rescinding a rescission and what have you. Even that is just sensationalizing a simple concept. There is nothing in principle that stops that from happening. No, the law allows us to think outside of the box. And if we do that, something that might look all scary really can be broken down to size. Let me take one step back. For example, nobody has ever argued that it is catastrophic, for lack of a better word, to appeal a decision refusing an appeal. Actually, if you take it to its logical conclusion, you could have a judgment from the magistrate court, appealed to the High Court, appealed to the full court, appealed to the Supreme Court of Appeal, appealed to the Constitutional Court. So in that example, you'd have an appeal of an appeal of an appeal of an appeal of an appeal, right? Nothing wrong with that. That actually happens every day. So again, logically, let's just take Rule 42 for convenience. Rule 42 says you have a right, rather the public protector has a right, or any litigant, to rescind any order of a court, right? So I don't know where this hullabaloo comes from, because any order of a court means exactly that, any order. That rule doesn't say you may have a rescission of any order, except if that order happens to be a rescission. Doesn't matter whether it's about a car.
No, I understand your argument.
Yeah.
But the position is this, the factual position is this in this case, is it not? That the Apex Court, our Apex Court, has refused the rescission application.
Yeah.
And now the applicant has sought from the Apex Court a reconsideration and or a rescission of that rescission application. So the finality of the matter was when, was it not? Was the finality of the matter not reached when the Constitutional Court refused the rescission application? Is that not, for want of a better word, the end of the road?
No, it's far from it, Justice. Saying that is the same as saying, which was dispelled in the case of Tassima, which was Department of Transport by the Constitutional Court. It's the same as saying, you put an appeal, right, let's say in the ordinary court against a single judge. Then that appeal, or rather the application for leave to appeal is dismissed, or even the appeal itself, yeah, to make it easier. And then you say that's the end of the road. No, it can be. The suspension that is created by Section 18 operates right until the Constitutional Court. That's what the effect of TASIMA says. So in other words, even if that appeal again is dismissed in the SCA, it's not the end of the road, because if you, within 15 days, you appeal to the SCA, how can it be the end of the road? It's a failure to understand as I say, the fundamental purpose of the rule that we contend for. The fundamental purpose of the rule is to protect the litigant until such time that finality has been reached. How can it conceivably be the end of the road?
So if the Constitutional Court had to now refuse
Set aside
the reconsideration order, and the applicant had to again file an application asking for rescission of that reconsideration order, and if that's refused, the applicant files another application asking for the rescission of that, it will carry on ad infinitum.
Yes, that's what the DA representative in the committee said last week. No, that's also wrong. Firstly, I'm not concerned about the ifs of it. But again, Justice Bele, to make it simple, I'll take this thing to the analogy of the appeal. Nobody can logically argue, no lawyer at least, can argue that, well, if your appeal fails at the High Court, what stops you from going to the SCA? The answer is nothing. And then they say, if your appeal fails in the SCA, what stops you from going to the Constitutional Court? The answer is nothing. And if you fail, I'm sorry.
For purposes of granting Part A,
yes,
we have to take a peek
yes,
into Part B.
yes.
So for this court, in order to say there are prospects, are we not supposed to look at where do we draw the line?
Thank you. Thank you, Justice Delamo. No. The answer is a big no. And it is what I've just explained now, that the issue of the peak only applies to the outer test, right? The outer test does not apply. This is very, very important. The outer test, according to JAFTA's judgment, paragraph I think 105 of the EFF versus Godan matter, the so-called peak and all that of clearest of cases, that test does not apply to the suspension relief that is sought in prayer 2, right? So, so I think this paragraph 145, you'll find that at yes, it's 113. In the bundles, you'll find it at page 70 of the authorities bundles, Justice Tolam.
But then, what happens? And I'm latching on the questions by my brother, Justice Ville. Does it mean the process comes to a standstill, or what does that mean?
Yes.
Do we wait until the applicant comes back and say, well, I've exhausted this, or
no, the
where
problem,
do we draw the line?
Yes. The problem with that approach, Justice Dolamo, firstly, is that it's pure speculation. It's based on absolute speculation as to what might happen. I'm talking about the concrete situation facing you now. Okay, what is going to happen in the future will be dealt with by those people. The concrete situation before you now is simply that there is, for lack of a better word, another process, whether it's an appeal or a rescission, as I've explained, should make no difference whatsoever. If you look at it with the eyes of Section 34 of the Constitution, is there, as Justice Vela said, finality? Yes or no? The answer is obviously no, because there cannot be finality when there is another pending process. Otherwise, let's close down the Constitutional Court and say whatever process is there, or let's strike out Rule 42 as unconstitutional, because it might bring us all sorts of speculative things. But for now, before anybody does that, the only question is the one that Justice Vela is asking. Is there another process pending, yes or no? And in my respectful submission, that is where we are. And therefore, the answer is a very simple one, which is that where there is a possibility, and I would put it no higher than that, Justice Vela, where there is a possibility, a legal possibility at that decision might be reversed, then this court must respect it. That's all. We're not asking for any favors, not asking for anything more than that, but simply saying where there is a possibility. And you will remember.
How do you gauge that possibility?
No, you don't gauge it. That's the point. You don't. That's why.
So we simply say, the minute he puts an application, we stop.
Yes.
Or we look at the possibility. The possibility says, how do we test that there is a possibility?
You actually don't, and the reason I've been
So we simply stop.
Yeah, yes, actually, literally. I'm doing this because I think I had asked, or no, I meant to ask Mr. Masuku to bring volume 2 of Erasmus, but I'll
And that's going to be fully argued in Part B. Alternatively, on the direct access.
No, Justice.
The development of the common law.
Oh yes, of course,
Yeah.
of course. Yeah, yes. No.
To have that
yeah,
effect.
that issue itself will be argued. I'm simply answering. Oh, perfect. If you go, I think it's for 550.
You're going to go to Rule 42.
45A.
45.
5 big A. You go to page D1-604 of Erasmus. There, the reference is made to the judgment of, in a case called Gois, G-O-I-S. I think it's one of the cases. We'll get to it when we get to it. But just to answer the specific question, it puts A, B, C, D, E of the criteria to be used in suspending an order pending a rescission. And this is one of the things the court said. The court will grant stay of execution where real substantial justice requires it, or where justice would otherwise result. I'm just signposting that because that's important. So the only test in this connection is whether the injustice might result. And I'll come to that in another context. For now, assume...
For now, we're dealing with the possibility.
Yes. Let's just deal with the possibility or the irrelevance of the possibility. This is then what the court said. The court is not concerned with the merits of the underlying dispute. The sole inquiry is simply whether the causa is in dispute. In other words, whether the underlying causa is in dispute. Is the underlying causa in dispute here? Yes. But you are not concerned in this, you cannot be concerned, you should not be concerned with, or it would be unlawful for the court to want to pick, because that is a test. Remember, Justice Dolami, this thing is very simple. It's the example I made about appeals. You never say, if I say to you, my lord, I'm standing here, I'm telling you that yesterday, in the judgment you gave, we filed a notice for leave to appeal. And my opponent says, I confirm that, my lord. You don't say, I want to see it.
No, the thing is with application for leave to appeal, you apply. You don't simply say, I filed a notice, then nothing must happen.
No, you don't apply. Nobody applies to file a notice to
No, no,
application.
I'm not saying filing the notice you apply. I say you file an application.
Yes, the
To
same
appeal.
way. That's exactly what we did.
So there is a mechanism to sift whether there should be that possibility.
No, there isn't, my lord.
Why?
Believe me.
I'm using the analogy of leave to appeal.
Yes. I'm
That's
saying,
why you go back to that court and say to that court, grant me the leave to go and argue further. So that court, what does it do? It has to look at the possibility of another court
okay, no,
coming to a different conclusion.
Yes. No.
Are you saying in this case it's different?
no,
The mere filing is sufficient?
no. It's exactly the same, identical. You are ahead of us, Justice Dolamo. You are talking about the situation where the application for leave to appeal is being evaluated. I'm not there. No. I'm talking about literally a situation where you gave a judgment yesterday, and the successful party then wants to execute on that judgment. If I stand up, Justice Dolamo, and I say to you, Justice Dolamo, yesterday afternoon I filed a notice of application for leave to appeal. That is the end of the matter, right? Not
Yes.
whether they appeal or assess what, that will happen next week when we come and argue. I'm talking about now. So you are, that's why I'm saying you are ahead. The mere, M-E-R-E, the mere filing of that notice suspends the execution of the judgment. The mere, right? It's got nothing, zero to do with the merits. Where the merits come in is a different thing, again, mostly misunderstood. If I then apply, or rather the successful party then applies for section 18.3,
Yeah.
right? Then one of the factors that the court must consider in a section 18.3 application is prospects of success. But before that, it says it's completely irrelevant. So that is, so the default position, if you like, is that you don't have to.
So what I would like to hear from you say is, at this juncture,
Yeah,
once you file that, that's the
That's
end
enough.
of the story. Is that your
absolutely.
point?
I'm saying, yeah, in the exactly the same way I've just explained. The mere, if, again, Justice Erasmus has actually correctly situated, this debate obviously will be had one day when the common law is developed or not developed. But if, when that happens, the rule that we contend for is exactly identical to Section 18. Namely, that the mere filing should suffice. Anyway,
Mr. Mpofu, my question is slightly different. The application currently pending before the Constitutional Court, that's the final step. If so, because
yes.
if your argument holds, you can bring an application if they're against you,
I don't
another
know.
application.
I don't want to
no,
go there.
No, I'm just saying, in principle, if you're correct, you can do that. But that is the final step of case number 2107 of 2020, where Part A was heard by Saldanha, Samela, and Steyn as a quorum.
No. It's got literally nothing to do.
No,
with
no,
that.
no. It started there. Part A was heard by that bench.
Yeah, but that was done.
No.
Okay,
Then Part B was heard by the second bench.
correct.
That was Bartman, Delamo,
And Nukuje.
and Nukuje. Right. They heard Part B. Part B went to the Constitutional Court.
Correct.
The appeal against Part B. That's the judgment that was given in February, and then the application for rescission, which was then, was it 6th of May, and then your application on either the 10th or the 11th.
Yes,
So it's
that's
all the continuation of the case that started under case number 2107
Yes, yes.
of 2020.
100%. 100%.
No, don't go too fast, Mr. Wolf. You appeared in that case, according to the reported judgment.
Yes.
And the relief sought there was against some of the same respondents
Yeah.
here. So it was for anybody that would participate in the Section 194 process, not to take any steps. I'm summarizing.
Yes.
Right. It's actually contained in paragraph 3 of the judgment that you will find in the authorities bundle at page 587,
Yeah.
from page 5.
Yes.
Now I've compared that relief that was sought there under Part A before the full bench in this division to the relief sought under your notice of motion, now amended by substituting the word concerning with
Right.
commencing. Isn't it the same? Effectively.
No. Not by any stretch of the imagination.
No. I'm saying the primary relief sought, 194 committee, you cannot do anything further. Wait for this application. I'm calling it the 1011 application that was filed in the Constitutional Court. The application then was, don't take any steps until Part B is heard and all final decisions of Part B. Am I right?
No, you're right. But you are wrong in another
So
respect.
I'm asking you the following. Part B, the current case before the Constitutional Court, was Part B of case 2107 of 2020.
Yes.
Now, the full court in this division denied your application, refused it for an interim interdict pending the finalization or the conclusion of those processes.
No, I know the argument.
And that
It's
was,
in the papers.
and that was never appealed. Aren't we bound by that decision unless we find they're wrong?
No. Three reasons, simple reasons. One is that the relief, so I saw that argument. It's actually, I can't even believe that it has been raised. It's raised in the guise of res judicata and issue
Estoppel, yeah.
Okay. Let's deal with it one by one.
No, I thought let's get it out of the way.
Yes, no.
On
I
your
appreciate-
argument, and then we move
I
on. with
appreciate
it.
that. Then we know all the preliminaries are out of the way. That argument, with the greatest respect to its originators, is fallacious. Firstly, the relief sought. Okay, now let's start with base one.
Let me
Base one.
show you my hand.
Yeah.
Why I'm asking you the
Yeah.
question. When you answered my brother Delamo, you referred to a number of cases.
Yes.
And I recalled when I was preparing that those arguments were actually dealt with by Saldanha J in that judgment. He dealt with all those cases.
No. Okay, let's do it. Firstly,
Yes.
a judgment in an interim judgment is not a final judgment. So I'm starting even before we deal with the realities. So there is nothing. Let's assume literally, which is wrong, by the way, that this was exactly about Part B, the old Part B, literally.
Challenging the rules
Yes.
and
yes. In other words, let's assume that before we appeared before, let's call it the Bartman Court, which was in June last year. Let's assume that in April, we brought another Part A application, right? And said, we know that the Saldanha J court dismissed the Part A. But now, because of ABCD or whatever that has happened since then, last week we found some big letter that says, this is a conspiracy, or whatever, okay?
Yeah.
And then we bring it. No court in this country can say no. But Mr. Mpofu, remember that last year or 2 years ago, when you did not have those facts, you had Part A, and therefore it's a res judicata. I mean, what is that? Number one. Number two, no court in this country would say, I'm bound, quote unquote, by the judgment of Saldanha J. So that's the first thing. The second one is that the nature of the relief sought in this version of Part B, and I'm working with you here, Justice Erasmus, in this version of Part B, is completely different to the nature. I'm now talking about the cause of action.
No, Mr. Mpofu, I'm sorry. Mkhwebane says clearly that the cause of action, the fact that res judicata doesn't apply because of the lack of sameness of cause of action is misconceived. Mkhwebane says sameness is determined by the identity of the question previously set in motion. It's got nothing to do with the cause of action.
No. That case does not do away with the general rule. The general rule stays, it comes from the common law, that the cause of action might be the same. It's a qualification of the general rule, which is correct, which simply says that the sameness must be looked at by the question. Okay, let's take that.
Issue. If you look at the Henderson principle, it talks about the issue,
Yes,
and
yeah.
that ties in with Mkhwebane.
Yes, but that's issue estoppel. Let's not confuse issue estoppel with res judicata.
Well, issue estoppel is a form of res judicata.
In that case, then let me argue them together. I never thought so. But if they are the same, then the issue, let's then deal with it at the level of issue estoppel, because as you correctly point out, Justice Bell, if issue estoppel doesn't apply, then a fortiori res judicata won't apply. If, as you say, they are the same thing.
Well, that's if you are raising issue estoppel in the form of res judicata. That's what I seem to have seen what has been raised by your opponents on the papers.
No,
I think that's what they raised.
No, they didn't do anything of that sort. What they did was to raise judicata, and then in the alternative, they say if res judicata doesn't apply, then issue estoppel. But it does, for the purposes of what I'm saying, it really doesn't matter. Let's take it at its lowest. Let's deal with it as issue estoppel. Stroke res judicata. Still, the test will not be passed by them, because the issue, this is really the point I was simply making, the issue that is now pending, quote unquote, in the Constitutional Court is not the same issue that was hanging before Saldanha J. Let me explain why that is so. Firstly, the one issue, which is the participation of the judge in the independent panel. Yeah. Now, the issues that are raised in this Part B application, quote unquote, are that the Constitutional Court, among other things, did not apply its own standards on separation of powers. I really don't want to go down that road, but it looks like I might have to. So that's the issue that is identified by them as if it's the same issue. No. Secondly, Justice Villa and Justice Erasmus, who raised this question, the Section 21B The reason why we pleaded section 172(1)(b is deliberate, because we are circumventing this kind of discussion. Section 172(1)(b of the Constitution is for a suspension order, right? Which is a completely different legal animal to an interim interdict. Sorry.
All right, you may proceed.
I
I
don't
see
know where
it was somebody on the virtual platform, an attorney, but he's muted himself now.
Yes. That much.
Just one
I'm
moment,
sorry,
simple
yes.
would be for. Can we just ask if everybody on the virtual platform, just mute yourself for the whole proceedings until we call upon you. I know it's difficult, sometimes it happens by mistake, but Mr. Mpofu is now confused because of that. All right, so the section reads of being a constitutional matter within its powers. A court, and then B, may make an order that is just and equitable, including, and the portion you're referring to is under sub 2, an order suspending the declaration of invalidity for a period and so forth.
Yes. But thank you. That's what the section says, Justice Erasmus. But I'm making a more fundamental.
So they can't see him. Okay, so just correct it. Just check
It's
it.
just the screen because they're still here.
No, it's the laptop facing you that is frozen, so
Oh, I
they'll be
see.
able to hear you,
So they can't see me.
but they won't be able to see you.
That's what this is.
So Ms. Francis will just sort it out, and but you may continue because
Yes.
everybody
Because
can
if
hear
you
you.
can hear me, yes. Thank you so much, Justice Erasmus. I'm saying I'm making a more fundamental point, and it is this. And unfortunately, again, it previously was not understood. So I'm hoping I'll try and explain the judgment of Chapter J in EFF versus Godan, the second judgment, is exactly on this point. And that is why I always, when I want to elevate that judgment above outer, I do what I call a head count. So I say that judgment, unlike many judgments.
You may continue.
Thank you, Justice. I'll just allow it. No, of course.
We're just trying to get hold of the IT person because that's her laptop.
Yeah. Okay, thank you. Nalani Junior just.
Let me just check with the other counsel on the platform. Can you hear us without the camera being on, Advocate Mpofu? Advocate Breitenbach?
Yes, my lord, I can hear everything clearly.
Oh, good. Advocate Pillay, just check.
Yes, my lord, I can hear everything clearly.
Thank you. Mr. Budlinder?
Yes, thank you, my lord.
All right, so, and there the camera, I can see them. So, Mr. Mpofu, I propose you proceed until we sort out that camera, because everybody can hear you and they can see us.
Yes, thank you very much. Thank you. But before I continue with what I was saying, just to dispose of a small issue. Page 567 for Justice Vele, you'll see that what is pleaded there, it says, Advocate Mkhwebane is pleaded by the principles of res judicata or issue stopped from seeking what is essentially the same thing. So it's not, they don't argue it as the same thing as proposed.
But they make the point, it's
They make
page 18 or 19 of the heads.
1A of the heads, their heads.
Yeah. When they deal with issue estoppel, they say under paragraph 52, it's page 21 of the heads of argument. They make the following submission. They say issue estoppel is a modification of the classic res judicata, and then they refer to a number of cases under footnotes, under footnote 45, and then they expand on that on the next page.
Okay, that much is true. What has been said, actually there's another case I'll give it to you maybe in reply, which actually even doubts whether issue estoppel is part of our law. But that's aside. There's no doubt in my mind, at least on anybody's mind, that issue estoppel is what one might call a species or a sub, it's in the same family. I forget now the genus and the species and all that. But it's not the same thing. That's the point I was making. That's all I was saying. It's the big mother of that family is res judicata, and then it might have a whole lot of other children. So I just wanted to clear that up.
Yeah.
Anyway, I was not there. The point I was making, Justice Erasmus, is this. And I was when we got cut off, I was making this point that how I normally elevate EFF versus Goda, depending on which side of the argument. And that we do by the following. That judgment, I always say, is the only judgment, well, it's not the only one, but it's a judgment which has been actually made by 22 judges. And everyone said, how do you come to 22? It is because the judgment of Hampepe J, which is the main judgment, was unanimous for the whole court. But so was Chapter J's concurring judgment. It's also consented for by the full court. So the two judgments put together each have, unlike outer, by the way, outer, as I pointed out in our heads, has a very strong dissent, which I'm sympathetic to, by Froneman J. But here we have a unanimous ×2 judgment. The only contribution that Justice Jafta wanted to make, Justice Erasmus, was to give an answer to what you're saying, that the relief sought in a suspension order is not the same thing as the relief sought in interim interdict. Hence, he said outer doesn't apply, which the answer I gave to Justice Galama in a different context. Now, what has that got to do with this so-called issue estoppel, or whatever you call it, issue? It is that it's two things. The relief sought in prayer 2 has got nothing to do with is a suspension order, and that is why it says there, in terms of Rule 45A, alternatively in terms of Section 172(1)(b. That's what it says in the notice of motion. That means that that relief belongs to the category that Chapter J was talking about. At 113 of EFF versus Godan says, however, the High Court did not limit the remedy it granted towards an interim interdict, unlike the Saldanha J court, right? It went further and suspended the operation of the remedial action pending the final determination of Part B, right? And then it gives the order. I'm reading from 112, if you're there, Justice. Mm-hmm. Then 113, which is where the crux is. Therefore, even if it could be said that there were prospects against the grant of the interdict, the applicant for leave would still be faced with the question whether there were prospects against the suspension the suspension. Requirements for suspension differ from those needed for an interim interdict. Can be clearer than that. In other words, this is a completely different issue, cause of action, whatever you call it, whether you do it as issue estoppel or as proper res judicata. It's not the same thing that was faced by what's by the Saldanha J court, or rather, at least not the same thing that it's decided. All right. So that's the second answer. The third answer.
But he also dealt with the 172 argument.
No.
It was raised for the first time in argument before that court, and he dealt with it in the judgment.
Not
The 172 point.
well, he might have dealt with it in the judgment. I'm talking about I'll check that. I'm talking about the order. The order that was granted is the same as the one that is referred to in 112 that I've just referred you to. If he dealt with it, that would be a miracle. But miracles.
Well,
do-
you were in the case. I read it in the judgment, and
I'd
I
say
can
I'm-
find it for you.
the basis that miracles do happen, maybe it will be there. But the point I'm simply making for now, Justice Erasmus, is that certainly the relief that was granted on the basis of interim interdicts and outer and all those things, not on the basis that outer does not apply. Actually, that's what it dealt with, whether outer applies or not.
Well, he deals with outer, and then he says in paragraph 24 of the judgment, to be found at page 593 of the bundle, the consolidated bundle of authorities presented to us.
593.
In respect of the relief sought under section 1721B and raised for the first time in argument, I'm quoting from the judgment of Saldanha J.
That would be from
In argument in the reply by counsel for the applicant, that was you, he submitted and so forth, and then he says, I will revert to this contention, and later on in the judgment he then deals with the issue. So it's not that 172 was not before the Saldanha court. That's the only point I'm making.
All right. The order, right? The order, the relief made by Saldanha J, and this, there can be no miracle about this one. The order was made on the basis of the application of outer, right? That's that is beyond debate.
And he said outer applies.
Yes, and he said outer apply. That's the giveaway. The point I'm making is that if outer applies, outer only applies to interdicts, right? As Chapter J just explained now.
Yeah.
That in the same paragraph I was reading now, the part I didn't read, I thought it was irrelevant, but now it has become relevant. The last sentence of paragraph 113 of Chapter J's judgment is that outer does not apply. So insofar as there's also some weird suggestion that you are also bound, in other words, in the sense of res judicata, stare decisis, which is worse. So now we have three animals here. We have stare decisis, we have res judicata, and we have issue estoppel. Insofar as that is suggested that you are bound by that judgment purely on the basis of stare decisis, that is just fallacious again, because the ratio of that decision was the fact that outer applies.
I say to you, I'll find it for you. It's on page 610 of the bundle. It's paragraphs 128 to 131 of the judgment
That's 610,
by the full court. Yeah, it's 610 of the consolidated bundle of authorities.
Got it, yes.
And then he comes to the conclusion at the end of the day. He says, I'm satisfied that it is just and equitable that the process of the removal of the applicant in terms of the new rules not be suspended, and that the applicant has likewise not made out a case for the relief in terms of section 1721B of the Constitution.
Exactly. Which
And he deals with, when he summarizes your argument, he uses the words that you've used in argument here, the nuanced approach of Jafta J in the second majority judgment and so forth.
Yes.
Yeah.
No, Justice Rasmus, please.
You don't have to beg me.
No,
Good.
I think I have to. You're taking us back now to the first point. The first point which I made, which I was making when I was told that, no, let's do it as issue a stopper, which I've agreed to. Let's do it as issue a stopper. One can never say merely because there was an application to suspend something called X, okay, which was the even before the so-called independent panel even existed. Okay, this was like early days. Actually, I don't even think I think the only thing that had happened then was submission of the motion. Okay, then you say, remember, let's look for the word suspension. Even now, though now you are suspending something called Y, which is the committee, let alone the independent panel. We've even gone many steps ahead. And then you say, no, but let's just search for the word suspension. Because here you are asking for a suspension, and here you are also asking for a suspension. Therefore, it's a res judicata or I'm bound. If that is the law, then I don't...
No, all I'm pointing out to you, the argument is made that the application before the Saldanha court, it was a full court led by Saldanha J, was an application to interdict the Section 194 committee and whatever else goes with it from proceeding under the new rules that included the judge panel, if I can say that, and then the non-legal representation. I'm just taking those two. The full court then, the Bartman full court, found those two are unconstitutional. I'm just saying unconstitutional in the broad sense of the word. You then went to the Constitutional Court, so it's then a continuation of Part B, because that was Part B, that was heard by the Bartman Court. And the Constitutional Court said, no, the judge panel, that's okay, there's no problem there. Legal representation, issue new rules. Then you applied for a rescission of that on various grounds on the judge panel issue. That's how I understand it. Yes. And then, of course, then 6 May happened, and now the application. But there are new facts that might have arisen that will impact on your application, the new application, the 10/11 May application. So that's the logic that they take it through on the line, and they say, so all of these issues were raised. You asked for an interdict before the Saldanha panel to stop the process that's going on. That's been dealt with. And there's nothing new in that. Same facts, same parties, and so forth. And they mention the 4 principles, and then refer to ALTA and so forth. Yeah.
Okay. I didn't want to interrupt Your Lordship, but the starting point of that summary is wrong, because you said, my Lord, that before the Saldanha court, we wanted to interdict the committee. No. It's a crucial point that I'm trying to make. We did not want to interdict any committee. There was no committee in existence. It was long, long, long before such a thing was born. the Saldanha Court, and this is the crux of what I'm trying to articulate here. Saldanha Court was, that's what when I was making these examples, was interdicting something completely different, right? Whether you look at it as a cause of action or as an issue or whatever, but it was a different animal.
It was called in the notice of motion the section 194 process.
Yes, but we've just agreed that if new facts emerge, I'm trying to explain to the court what new facts have emerged. I'm saying those new facts are that there is now something called a section 194 committee, which was not in existence at the time. Right? Now, I'm therefore saying that according to Mr. Breitenbach, and we all embrace that, there is what is called a 17-step process. And that's important, again, because this confusion is made sometimes deliberately between process and proceedings, and I'll deal with that in another context. But let's take Mr. Breitenbach's 17-step process. All I'm saying, Justice Erasmus, is that when we were before the Saldanha J court, and I can't remember now, let's say we were at stage 5. I'm just making it up, right? I mean, step number 5 or 7. Okay. Now we've moved the new facts before you, and that we have moved from 7 or whatever it is to 14, let's say. Again, I'm not married to that. I'm making up the numbers to make the point. So that movement from stage 7 to 14 presents exactly what I am articulating as the new reality. It's the same as that ridiculous example I made of we found some smoking gun or something. Okay? So this is, at a legal conceptual level, that is the relief sought or rather, the relief granted at a particular point of point 7 cannot be equated at any level, whether it's as an issue or as a cause of action, to the relief now sought. And that really comes from a very simple principle of law. That is exactly why you are allowed to bring interim interdicts ad nauseum, if you like, to go back to that example of where do you draw the line. You don't. If I bring an interim interdict down and then some new facts arise, I can bring it again and fail. And another set of facts arises the following month, I can bring it again. There's no line. So it doesn't have to postulate all these ridiculous things, because imagine if I came to this court and said, at now stage 9, there are new facts that have arisen, I want another interim order. And then the court said, well, what will stop you from coming again at stage 10? Nothing. That's the answer. So it's very easy to exaggerate the problems that have not existed or that are not that are postulated by so-called experts who are writing in newspapers. But the reality facing us is that relief is qualitatively different. And I'd like to move away from it, because I have no doubt that the so-called...
No, the first and second respondents are going to argue that point,
yes,
strongly. And of course, if we're with them on that point, then it's the end of the matter. So I wanted to give you enough time to deal with it, and deal with it up front before you get fuzzied by all the other issues later in the day.
Yeah. Well, firstly, okay, that forces me to deal with it now.
Yeah.
Because it cannot be the end of the matter. It cannot be, because the application has now been brought on 3 alternatives. One is the normal interdict, Sitokelo, outer, whatever you like. 2 is Rule 45A, and 3 is 172B. If anybody is going to tell us that that is the same thing as what was argued before Saldanha J, well, then that's the end of the road.
Mr. Mpofu, this is where I have some difficulty in understanding your argument. Let's, for the purpose of my debate with you, let's forget about the words relief, and let's forget about the words cause of action. Let's think for a moment about the words issue. What was the issue that was determined in front of the full court headed by Judge Saldanha, and the issue that was determined by the full court headed by Judge Barton? What is the difference between those issues and the issue that is before us?
Okay.
Let's forget about remedy, cause of action, relief. Let's talk about issue.
Okay. That's even easier than the issue before Saldanha J is the one I explained by using my cell phone. I said the issue there was whether at stage 7, which I'm making up, the process should stop. Let's just say, for example, that was the only issue. And Saldanha J might have found that no, it's too early in the process, or whatever, for me to stop it, or I'm exercising my discretion or whatever. Right? The issue before Batman J's court was a completely different matter. It was whether the rules are unconstitutional. Okay? Not whether, because the rules might be unconstitutional one day, we should stop the process now. 2 different issues. Let's at least agree on that. Then the issue which is now before the Constitutional Court is whether the Constitutional Court committed a rescindable error in determining the one constitutional issue. By the way, Justice Erasmus, before I forget this point, so those are the 3 different issues, but I'll still come back, Justice William. By the way, the argument that, one of the arguments of the variations of this argument is that you are bound by Saldanha J's determination on the interim relief. How on earth can that be when that judgment was clearly wrong? Right? How? In which world does a judgment which has been overruled, for lack of a better word, and discredited, become binding to this court? How can the same judge, Saldanha, who said that there is no need for the public protector to have legal representation as part of the basis for his refusal of the Part A, which idea was poo-pooed by the full Batman Court and the Constitutional Court, no harm. And but honestly, and for anybody really to come here and say that that judgment, based on an idea that was rejected by the highest court in this land, is binding on you, it's just, I've never heard of such a thing in my entire life. the Saldanha judgment has been twice reversed on a crucial aspect, which brings us here. Had it not been, actually, you wouldn't be sitting there and I wouldn't be standing here. Had the Batman J Court and the Constitutional Court agreed with that wrong judgment, then we wouldn't be here. But somehow it now has some binding effect on this, please, not on this court. Anyway, I think that's enough said on that. It's just a red herring, please believe me. This so-called issue stuff or res judicata is nothing but trying to pull the wool over the eyes of the court. So, can I
Yes,
deal with the merits?
Yeah.
Yeah. Okay. I said there are 5 judgments. The first judgment, which I would like you to pencil in, is I can't believe that we all did not put this judgment in until yesterday. You would have received the judgment yesterday, the EFF impeachment case. I don't know if
it was also referred to in the Saldanha judgment.
It is, yes. That's why I'm saying
Yeah.
I realized it as I was getting into the aeroplane that for some reason this judgment is not here. It's referred to everywhere, even in the Mdntv judgment of the Constitutional Court. So it was just a faux pas. Now, that judgment, there's no way that this matter could be decided without referring to that judgment, really. Because, why? That judgment is the sans et erigo of these rules that we're talking about here. I know that because I was in that case, we argued there that you cannot impeach a president without rules. And as a result, we successfully argued that the judgment of Chapter G. And as a result of that, Parliament then developed, do we still have everyone?
Yeah.
Okay. The Parliament then, my lord, developed the Rule 89 rules. You'll remember that. Those rules were literally modeled. Whoever drafted those rules must have had that judgment and then drafted the rules. Okay. Now we know, as a matter of fact, that these rules, the ones before you, were in turn modeled literally on the Rule 89 rules. Literally, I think it's 95%. I counted it at some stage. There are only 2 or 3 modifications where it says president, it just says public protector or whatever, or Chapter 9 institution. But those rules are a carbon copy of those rules, of the Rule 89 rules. So it is impossible to assess a matter, this kind of matter, without looking at particularly the majority judgment of chapter. And that goes, by the way, to one of the issues I'm going to talk about the illegality, sheer illegality of the so-called committee usurping the powers of the Speaker and the National Assembly. That judgment makes it clear that the authority for these rules is the Speaker, or rather the National Assembly, or obviously by the office of the Speaker. But that's an aside. The second judgment is, no, let me deal with their implications because others are not so important. This one is very important. One of the issues that is said in the judgment of Chapter J, in the EFF judgment, you will find at sorry, I'll find the paragraph now. But this is a very crucial point which must not be lost here. He says that, and that goes to the rights now of the public protector that we're trying to protect. He says the reason why there must be rules for an impeachment process as opposed to a motion of no confidence, which we dealt with in another case, UDM, which is one of the big five. My Melanie friend, Party Hender was my junior. Again, there we successfully established the related principle. He says, Justice Chapter, the key distinguisher between this is because an impeachment process is punitive. I'm sorry. I'm sorry. I'm sorry. Yeah. Yes. It's paragraph 138 of that judgment. In contrast, the removal of the president by means of impeachment is subject to certain conditions. It must have as its foundation at least one of the grounds listed, section 891, and the impeachment itself must be supported by a 2/3 majority. The reason for this distinction in process is that impeachment is punitive. Let's just pause there. We know, remember, one of the issues we're going to be dealing with here is going to be an interpretation exercise of section 194.3a. Everybody knows, sure, that the interpretation of a penal or punitive section must be done in a particular fashion. Firstly, it must be done in favorem libertatis, in favor of the individual, but it must also be done in terms of section 39(2) of the Constitution and so on and so on. Okay? Now, hear this. Here, remember Justice Chafta was dealing with the section as a whole, section 89, which for present purposes is the same as section 194, right? As a penal provision. Here's the thing. Here you have a double penal provision. Now, something worse than what Justice Chafta was dealing with. Because within the penal provision, which is 194, we're now dealing with the 194.3a, which is a suspension provision. Suspension is, by its definition, by its own nature, punitive.
Why do you say that?
Because I've given you...
Suspension of whom? Because remember, before us as the applicant is the Office of the Public Protector. It's not the actual incumbent of the Public Protector.
Yeah.
That's the party before us.
Yeah.
So if you suspend, you have a precautionary suspension of the incumbent to the applicant. How is that punitive vis-a-vis the applicant that's before court?
Yeah.
The office continues.
No. They can't suspend an officer. You see?
I'm not just saying you can suspend an office.
Yeah.
I'm saying the incumbent is the person that may or may not be suspended. And how can you say that is a punitive measure? The incumbent will get full pay during that process.
Yes, okay. Finish. Thank you. All right. It is because, firstly, and I'm not saying this facetiously, you cannot suspend an office. You suspend a person, human being. All right? So the just as you cannot remove, it's the same thing that Chapter J was really trying to explain simplistically. That answer could be, how you're suspending the office of the president and not the president. No. You suspend as if you go to paragraph 139 of the same judgment. It's the same paragraph, depending on the ground which is based, the impeached president may lose all benefits and be barred from occupying any public office. So that's for the president. So let's call it punitive quality number 1 to distinguish it from the one that you are raising. So the punitive quality number 1 is that impeachment, which is, if it was a normal employee, would be dismissal, is by its nature punitive for the reason that Chapter J was explaining. Okay? So that's the impeachment itself. But what I'm saying, I don't think that's arguable, really, that an impeachment is punitive. At least that's what the Constitutional Court says. So I'll stick by that. But the point I was making is a further point, which is the one you are asking me, Justice Fellow. Namely, that within that punitive regime, which the Constitutional Court says we are now dealing with another punitive issue, which is called suspension. And you say, why? Because they'll be suspending the office.
No, I'm not saying that.
Oh, okay.
You misunderstood completely my question.
Yes,
I said a precautionary suspension of the incumbent to the office of the public protector.
Mm-hmm.
How is that punitive?
Okay. The precautionary suspension of the public protector.
Under the incumbent to the office of the
Yes,
public protector.
yes, but that's the same thing. Okay, let me make it easy. The suspension of Advocate Mkhwebane.
Yes.
Right?
Precautionary suspension.
Suspension.
With pay.
Yes, with pay, everything. Is in its, by definition, the suspension of anybody, including Advocate Mkhwebane, or a judge, or a president, or whatever, is ipso facto punitive, because and that is why Section 177(3) Section 177(3) of the Constitution
Yes, I'm with you.
thank you, Justice Bell. Okay, let's start at the beginning.
Where do you want to start? Section?
177(3) of the Constitution, which is the analogous section about the suspension of a judge. The President, on the advice of the JSC, may suspend a judge who is the subject of a procedure in terms of subsection 1. Now, the reason why that happens at a particular stage, the suspension of a judge who is being impeached, Justice Vele, is because it is a draconian and a very punitive. Well, I'm sure anyone who was the judge that is being suspended would know that that is nothing short of what in Mokutle was called. If you go to page 243 of the authorities bundle.
Mm-hmm.
His Lordship Justice Van Niekerk answered that question beautifully. It's one of my favorite expressions.
It's not one of the top 5.
Yes. No. This case is not.
Okay.
No. But it has just been elevated just for the purposes of this argument. No, it's a second-rate case. But I'm saying, second to what my favorite expression in law is the one that says it is better to release 9 guilty men than to convict 1 innocent one. But my second one is this one. It says that insofar as the substantive dimension of fair dealing in relation to suspension is concerned, I'm reading at paragraph 31. Halton Chidle has observed that suspension is the employment equivalent of arrest, with the consequence that an employee suffers palpable prejudice to reputation, advancement, and fulfillment. Right? So that is.
Give me a moment, please.
Oh, I'm sorry.
Thank you.
Yes.
Yes. Even the respondents, as they are, and where they insult Applicant Mkhwebane at the slightest provocation, particularly the 5th respondent, do not and cannot argue that her suspension, simply because she is getting paid, is sorry.
It's not punitive.
It's not punitive, yes, or at least seriously injurious to her rights. And that is because Justice Bele, by definition, and as I say, as someone who was once suspended, if maybe it's easy to theorize about this, but to be suspended from work, any work, is ipso facto, as Halton Chidle says, injurious, A, to your reputation, 2, to your dignity, right? And 3, to your self-worth as a human being. Now, only people who, where is the case, there are 2 cases which we cited in our heads.
There were other one by Sex J.
Nugent and then Sachs, yes. Yes. We start by, it is paragraph 80. Thank you so much, Justice Bellam.
Mr. Mpofu, once you finish this section, we're just going to take a short adjournment just to stretch and then come back.
Thank you very much. Thank you, my lord. Yes, I'll just...
It'll give us about 2 hours in.
Yes.
Since we started, and we'll take a short adjournment.
Yes.
Good.
Fair enough. Thank you, Justice. Right. We say paragraph 80, Justice Bele, of our heads, at page 30 thereof. It is indisputable that, well, we thought so, as a general rule and by definition, any suspension from work limits the suspendee's rights to dignity, reputation, and work. It has been correctly observed that suspension is the employment equivalent of arrest, with the consequences that an employee suffers palpable prejudice to reputation, advancement, and fulfillment, which is what I've just heard from Mokhoke. In the same vein, the SCA, by Nugent JA, made it clear that suspension with pay, which is your question really, suspension with pay does not diminish the adverse impact on the rights of the suspended. person because, quote, said Nugent J.M., the freedom to engage in productive work, even where that is not required to survive, is indeed an important component of human dignity. That aspect, which we were told in S. versus Mapanyane, is the fundamental pillar of our constitutional dispensation, dignity. 4, said Judge Nugent, mankind is preeminently a social species with an instinct for meaningful association. Self-esteem and the sense of self-worth, the fulfillment of what it is to be human, is most often bound up with being accepted as socially useful. That should be self-evident. But the Constitutional Court, because we've now taken it to all 3 stages, the Mokhotle is the lower court, SCA, what does the apex court say? Justice Sachs said in Masetla, fairness to an incumbent, which is the word you use, Justice Villa, incumbent. Fairness to an incumbent, right? Not to an office, to an incumbent, about to be relieved of a high-profile position in public life, presupposes the display of appropriate concern for the reputational consequences. People live not by bread alone. Indeed, in the case of career functionaries, reputation and bread are inseparable. I don't think that needs any further explanation. But to round off the point before we take a short break, the point I was simply making really is that assuming that it is not contestable that an impeachment provision such as Section 89, 177, or 194 is ipso facto punitive, which is what, well, it can be debatable because that's what the Constitutional Court said. Assuming that is not debatable, and assuming the second proposition I was making, which is that this is a double whammy, if you like, or a double punitive provision, because 194.3a, which lives in a punitive section, is in itself punitive because it's a suspension provision. So you, my lords, will have to exercise double the required effort in interpreting Section 194.3a in particular, because it is a double punitive statute. I think that rounds off that point. So the short break will be taken.
Will 15 minutes be the best time? I know that it's difficult for council to leave the court building, so I want to keep it as short as possible. So 15 minutes. So it's now 5 to 11. We will return at 10 past 11. 11:10. Court ledger.
Yes, I do. I do. But do you